We're going to talk about estate planning today. And I guess the first thing I want to talk about is sort of what do we mean when we say estate planning, right? And estate planning means coming up with a plan and the right documents to decide now, while you're alive and competent, what happens when you're not alive or competent, both with respect to what happens to your property, your assets, and also what happens to you yourself when you're not able to make those decisions for yourself. So those are sort of the two parts of an estate plan, both dealing with what happens when you're no longer competent to take care of your own decisions, and also what happens after you pass. So we've got an agenda today. And what I'm going to cover first is a will. People call it also as a last will and testament. Then I'm going to talk a little bit about trusts. I'm going to talk about a general power of attorney, which is a document that lets somebody else act for you when you can't act for yourself for a number of reasons, and we'll talk about that. A healthcare power of attorney, which is what it sounds like. It's the same thing, but specifically for health decisions. And then it's called an advance directive, but people sometimes refer to it as a living will. And it's a document that speaks directly to your doctor about things that you want to happen right at the end of life. After that, I'm going to talk about a couple of sort of general helpful things that you can do for your family to make things easier after you pass that aren't necessarily like an estate document, but just some ideas. And then we'll have questions and answers. So that's sort of what we're covering. The first document I want to talk about is a will. That's the basic estate planning document. What a will does is and I'm sure you all know this, but it's a document that's an official document that tells the court where you want your things to go after you pass. The reason and when I talk about like your property or your assets, I mean your house, your bank accounts, your car, your jewelry, everything. So I talk about property. But when I say property, I don't just mean real estate, I mean everything. Not everybody has a will. Somebody here just told me she doesn't have a will. And if you don't have a will, what happens to your property is it still passes, but it passes under this sort of formula that the state has come up with. For example, if you were married and you had a child and you passed without a will, what happens very specifically is that your spouse is going to get the first $30,000 worth of stuff, and everything else gets divided between your spouse and your child. Well, that may not be what you want. You know, your spouse may be fine. They've got a retirement plan or whatever. It's your child from an earlier marriage that needs all your help, doesn't have what they need. And you want everything to go to that child. Well, without a will, the state says, no, here's the formula. Here's how it's going. And it may not be what you would want. So a will is a way to decide now how you want everything to go. There are a couple of things that don't pass by will. And the reason I'm telling you this is because it's something you need to remember, because you think, well, I've got a will, I know how everything's going to go, but there are things that your will doesn't affect. If you've got a pension, your will doesn't have anything to do with where your pension goes. When you fill out the paperwork, you said, well, when I pass, I want it to go to so-and-so. Well, that's how it happens, no matter what your will says. If you've got a life insurance policy, it's going to go where that life insurance policy beneficiary says. Your will doesn't have any effect on that. If you have a bank account with a pay on death or a joint bank account, sort of something like that, again, it will go how that form said that you filled out at the bank. The other thing that goes outside your will often is if two married people buy a house together and their names are both on the deed, then when one of them dies, the other one owns the whole house immediately. Mm-hmm. So my husband and I own a house together. We bought it while we were married. Jeff's on the deed. I'm on the deed. If I passed, he'd own the whole house. Doesn't matter what my will says. So those are some exceptions you want to think about, because like you got a life insurance policy when you were married. It named your husband. Well, you've gotten divorced. You're like, well, I got my will set up. I know everything goes to my kids. But if you haven't changed that, your husband's getting a little surprised. And so are your kids, in not a good way. So you got a will. You're going to do a will. And you think, well, what are the things I want to think about when I'm putting this will together? first obvious thing is who's going to be your executor. Your executor is the person who makes the will happen. They go down to the courthouse, they file the paperwork, they fill out the forms with the bank, they fill out the title for your, all that kind of stuff. And you just want somebody who's not going to get all flustered by it. You want somebody that you can trust. You want somebody that hopefully is local. It's just easier for them. They can use an attorney if they want to help them. They don't have to. But think about like who that is. And you can, in your will, you can name your first choice and a backup. So, you know, I've named my husband as my executor. Well, if he passes before me, my sister's my executor, you know, so you can list them out. The other obvious thing you want to think about when you're thinking about a will is who's getting my stuff. How am I going to divide it? There's sort of three basic categories. You can make specific bequests, specific gifts in your will. I can say my older daughter is getting my ruby earrings, and you can name it. My daughter Leah gets my earrings. Spell it out. You can also make charitable things. I'm going to give Habitat $1,000. Ooh. You can spell that out specifically. Then what's left is what people often call the residuary of your estate. It's everything that you haven't specifically named going to somebody. So it's what's left, and that's your house, your bank account, your whatever it is you haven't specifically said I'm giving to this person goes in this residuary pot. And a lot of times where that ends up is with your kids or your grandkids. Or your spouse if you're married. And so you say, well, I'm going to leave to my children my residuary estate. So they're going to get everything. But this is why it's helpful to talk to an attorney when you're drafting this, because how you say that means different things. If I said, I'm giving my children my residuary, what's left, and I had 3 children and one passed, and that child who passed had kids, if I just say I'm giving it to my kids, it's just those 2 kids that are still alive that are getting it. You can say, and I want to give to the child of any child who's passed before me, any grandkid, they should get their parents' share, right? But if you just said, I'm leaving it to my kids and my grandkids, that's different again. Because if you got 2 kids, some of them have kids, you got other grandkids, it just gets divided up evenly. So you want to sit down with somebody and think about how you say that, so that it does what you want. You know, it's your document. You tell it. You tell the world how you want your things to pass. And what would happen if something happened in the future. I leave my document, my will says I leave everything to my husband. If he passes before me, it goes to my girls. Well, if one of them passes, how is that going to happen? And that's what you sit down with somebody and figure out. And that's why it's helpful to go to like a will clinic and talk about specifically what you want. And then they can help you get it the way you want it. In North Carolina, there's 2 ways you can make a legal will. One of them is to just write it all out, like with a pen. You can't print it and sign it. You write it out by hand yourself. You can do that on your kitchen table, and it's legal as long as you wrote the whole thing out. People don't do that very much anymore. It was more common when we were really a more rural state, you know, and somebody's living up in the mountains far from anywhere, or, you know, things like that. 99.9% these days, you're going to sit down and do a printed out form. And if that's the case, you need 2 witnesses and a notary public to see you sign it and to sign their name on it saying they see you sign it. Those witnesses shouldn't be your kids. They shouldn't be your husband. They shouldn't be anybody who's getting your stuff. And that's where, again, if you go to like a will clinic or talk to an attorney, they'll have people there who can do that stuff for you. If you want to change your will, you absolutely can. You do a will, you stick it in your safe box. 2 years from now, something happens. You get divorced, you get married, whatever, and you want to change it. You can change it as long as you are alive and as long as you are competent. We'll talk about competency in just a moment. So that's your first document. That's your will. The second document that people talk about is a trust. And I'm going to talk here a little bit more than what's on the PowerPoint about trusts, because we got some questions in online from people, and I want to address one specific thing that I didn't put on the PowerPoint. So where a will is like giving somebody a gift in their hands, A trust is putting that same gift in a safe box that somebody else can manage. And you would do this for a bunch of reasons. You would do it if you had children who were too young that you thought they couldn't manage things on their own. And that doesn't mean like turning 18 so you can vote. It means I don't think my kids are going to be ready to manage anything until they're maybe 25. You pick. And somebody else that you trust, which is why it's called a trust, is going to manage it for them until they're old enough. You can do it if you've got somebody that you know you want to leave things to, but for some reason they've got an illness, they've got a addiction, they've got a disability. You don't want, they don't think they're maybe not the best person to manage that asset for themselves. You can let somebody else manage it for them. That's the difference. So a will is just handing it to you, and a trust is saying, this is for your benefit, but somebody else is going to take care of it for you because you're not at a spot where you can do that right now. Some people had put questions through the portal or online when they signed up for this, asking about trusts when it came to protecting assets. And in particular, like protecting your house, for example. For a lot of us, our house is our biggest asset. And you can protect it from different things. You might want to protect it from different things, from a lawsuit against you, maybe. Or also people, I think, have questions about it how it intersects with Medicaid planning. In North Carolina, in order to qualify for Medicaid, you have to meet certain requirements about income, but you also have to meet requirements about how much your assets are worth. They don't count your house if you're living in the house, if your spouse is living in the house, if your minor children are living in the house, or if you're like in the hospital, but you plan on coming back to the house. You know, you're going in to get your appendix out. You're coming back. They're not going to count that house as an asset for purposes of deciding whether you're eligible. But if you needed to go into a nursing home or a care facility and you're probably not coming back, they're going to count your house, right? People, you can plan around that in different ways. And I'm just going to touch on this for a minute here because it's not really what this seminar is about. But you can make a gift of it to your child. You can also put it in a trust that's called a Medicare Asset Protection Trust. Medicare Asset Protection Trust, MAPT. And what that does is you put it into a trust for your benefit while you live in the house and then to your kids or whatever. And if it's in the trust, you don't own it anymore. So Medicaid doesn't count the value of it for saying you're not qualified to go into we're not going to pay for you to be in a nursing home or wherever, extended care. The trick with a Medicaid Asset Protection Trust is that it needs to be what's called an irrevocable trust, which means you can't revoke it. You can't undo it. So when you make this, put your house into this trust, that's it. You don't get to decide later on, I'm going to sell the house and take that money and go on vacation with it. You can't do that. You could sell the house, but the money would have to stay in that trust or buy another house in the trust. The other trick with this is somebody other than you has to be what's called the trustee of the trust, which means the person that makes the decisions about that trust. So, I mean, if you've got somebody that you really trust, your sister or your whoever, you can do this, but you need to do it with your eyes open to the fact that once you've done it, it's done and you can't undo it. And now anytime you want to do something with that house, like sell it or get a loan on it, you got to get your sister on board saying she's going to do it because she's the one who's actually going to have to sign the paperwork. So it's a big step to think about. And it's kind of beyond the scope of what we're talking about here today. But I think people had some questions about that. And maybe if people want to, we could talk about it another time, because I think it's an important thing to understand how that works. The final thing about a Medicaid trust is that Medicaid has what's called a look back, which means they go backwards. Like if, say, I need to go into a nursing home, they're going to look backwards 5 years and say, did I get rid of anything in that 5-year period that would have put me over the amount of assets where I'll qualify? They get to look backwards. And if you did, they can count that against you. So if this is something you're going to think about doing, it's something you need to think about doing well in advance of when you think you might be needing that, like a nursing facility or something, because they're going to be able to look backwards 5 years and go, no, you just 6 months ago, you put your house in a trust. We're still counting that house. So it's something that there's a lot of planning that goes into it, and you want to sit down with somebody and really talk about that before you make that decision. The next document that we're going to, well, I want to talk for just a second about competency, because I've been talking about that. You can change your will if you're competent. These other documents I'm going to talk about, you can change them if you're competent. Competency, when we're just talking to each other, it just means she isn't competent to run her life, right? You know, she's not competent. She's irresponsible. She's whatever. Competency, when it comes to signing these documents, is super specific, and it means you know who you are, you know who your kids are, or your spouse, or your grandkids, people who would be likely to get your things if you died. You understand what you're signing. You know, this is a will. It means I'm leaving stuff to somebody. And also you're over 18 and no court has said that you're incompetent. There hasn't been a judgment filed saying you're incompetent. So you can be somebody that all of your neighbors would go, she is incompetent to manage her money. And you're still competent to sign a will. It doesn't mean you're foolish, or it doesn't mean you're not smart about making decisions. You can be foolish and make a will. You can be at a point. I have a client who was 94. She didn't ever remember what she had for dinner the night before, and she'd forget people's names, and she'd tell you the same story 14 times, but she knew dang well who her husband was, who her kids were, and what she had, and who she wanted to get what. That's all that matters. She's competent for signing this. I had a client who had a stroke, and he couldn't communicate well at all. But he knew what he had, and he knew what he wanted to do, and we took some time, and it was a lot of yes, no words he could manage, but he was competent to do what he wanted to do. And he couldn't write his name anymore, but he could make a mark, and that's enough. So I just wanted to talk about that, because I'm going to talk about how you can change these documents if you're competent. And that's what I mean when I say competent. It's a specific thing. The next document that, or the next document you can sign is what's called a general power of attorney. And what that is a document that gives somebody else the decision, or the power to make decisions for you when you're at a point in your life when you can't. Could be for a short period of time. You had major surgery and now you're kind of unconscious for 3 days, or it could be long term. You know, you get Alzheimer's. They can make decisions. It's a very broad document. They can make decisions about your house. They can make decisions with your bank account. They can talk to Social Security for you. It's a really broad document, and it lets them sign your name essentially for you on things. Because it's so broad, it can feel really scary to have that, because you're like, I feel like I'm handing over the keys to my life to somebody, right? But there's a safety net for it, because the person that you name as your attorney in fact, or your power of attorney, has a fiduciary duty to you. They have a duty under the law, because you gave them this power, to only act in your best interest and to only take steps that they really truly believe you'd want to take yourself if you could. So there is a safety net. Because it's such a broad document, you need to think very, very carefully about who you want to pick. If you change your mind about them later, you can undo your power of attorney as long as you're competent. And it is a really useful thing to have, particularly as folks are getting older, where, currently my husband has my power of attorney. But, when we both get older, we'll probably name our daughters, because at some point I may not be in a place where I can make decisions for myself. And I trust my daughters. They're good people. They can make those decisions for me and get things done when I can't do it for myself. To sign a power of attorney, you have to do it in front of a notary. You don't have to have witnesses, but you do have to be in front of a notary. And it's something you can do like at a, at a will clinic or something like that. They'll have notaries there. A lot of times banks have notaries. There's different, and there's people who just, you can Google them. People will come to your house and notarize something for 25 bucks. There's another kind of power of attorney called a healthcare power of attorney. And it is the same deal, but only for healthcare issues. What it does is it lets somebody talk to your doctors, see your medical records, decide you need to go into an assisted or a nursing home and which one, deal with your insurance benefits, decide what treatment you're going to get. If you're in a coma forever and ever, they can decide whether you should be fed through a tube or not. All of it's, again, it's a big document, but it lets somebody make those decisions when you can't.
Are those based on a predetermined, your own wishes?
So under the North Carolina Healthcare Power of Attorney form, there are places that you can limit what somebody can do for you. You can say they can make all these decisions. They can't make mental health decisions for you. That's a check the box on the form. You can say they can't decide on an autopsy. You can say they can't decide on a feeding tube for you. You can narrow it. You can't make them make a certain decision for you. And we'll get to that in a moment. But you can limit the things they don't get to do. When you're talking about who should be this person for you, you want to think about a couple things. Somebody who's really going to respect, who you've had a chance to talk to and knows what you want and who you trust will respect your wishes, and also somebody that you think is going to be strong enough to do what you want. I have a client who has a lovely daughter, lovely son. They're both good people. She loves them. They love her. When I was talking with her about this, she said, oh, my daughter needs to have that. Because both of my kids know I don't want to be on a respirator ever, unless it's short term. I don't want to be on a feeding tube ever. They know that. My daughter will do it. My son is never going to be able to say, it's time to unplug mom. He's never going to be able to do that. So I'm naming my daughter because she's going to do what I want. I have another client and she has two sisters and they're all like right at the same age and they're thick as thieves. They are close. And when I was talking to her, she was like, oh, I'm having Julia because I know Stephanie would unplug me in 20 seconds. So you want to think about who you're going to do, right? And are they going to be willing to do what you know you want to do? When my mom was dying, my sisters and I were with her and we were talking to the doctor and he said she developed pneumonia, which was not why she was dying. She was dying from cancer, but she'd gotten pneumonia. And he said, do you want us to treat the pneumonia? She's maybe got another couple of weeks left of the cancer, but we can treat the pneumonia. Otherwise the pneumonia will probably cause her to pass away in the next 48 hours. And I said, no, she wouldn't want that. And my sisters both said the same thing. She wouldn't want it. She'd come back and haunt us if we did that. But we were able to do what we knew she wanted. And not everybody can do that because it's their own heart at stake. With a healthcare power of attorney, it's the same thing. You're going to sign it in front of witnesses. You're going to sign it in front of a notary public. You can change it as long as you're competent. You can change it anytime you decide these aren't the right people or you've changed decisions. The last of the big documents is called an advance directive. People call this lots of different names. They call it a living will. They call it a declaration of a desire for a natural death. It's got a bunch of different names. And it's sort of like a healthcare power of attorney in that what it talks about, but it's really different in a couple of particular ways. What this is a document that tells your doctor directly what you want at the end of your life. So this isn't about you've had heart surgery and you're kind of out of it for a couple of days. It's not that. This is right at the end of your life. And it talks directly to your doctor. So it's not your healthcare agent. Your daughter doesn't have to talk for you. This talks for you. And it comes into effect in one of three ways, and you get to pick all or one of them, or none of them. You don't have to sign one of these ever, obviously. It can be when you're at the very last stages of a terminal illness, like my mom was. You've got cancer, you are not going to get better. we're down to the last couple of days to a week. Not 6 months. The doctor says I have 6 months. It's not that. This is those last hours when you can't talk for yourself. If you are in what people call a persistent vegetative state, you're in a coma, you're never coming out of it. You'd had some terrible car accident, brain damage. The doctors are saying she's never coming out. He's never coming out. Or if you've got really advanced dementia, you've got Alzheimer's, not you don't remember people's names, but like at the point you can't feed yourself, you can't speak, you can't feed yourself, that very end part of that. Those are your 3 times that this could come into effect. And you get to pick any or all of those. Once you're in that point, what then happens is that you tell the doctor things like, do I want life prolonging measures? If I'm there, if I'm in advanced Alzheimer's and I can't feed myself and I can't talk and I don't know where I am and I'm just sitting there in my hospital bed, do I want to, and I got pneumonia, do I want the doctor to treat my pneumonia? And should I be still on my blood pressure medicine? If we get to a point where you're at the end stage of cancer and you can't do anything, do you want a feeding tube? Do you want a breathing tube? All of those things. And the form is really detailed and you get to pick each and every one of these things. So for example, my own healthcare or my own advanced directive says in any of those conditions, if I get pneumonia, I get pneumonia. Don't treat it. If I'm on blood pressure medicine, don't give me the blood pressure medicine. If I have a stroke and die because my blood pressure goes too high, it doesn't matter at this point to me. I don't want to be fed, but by damn it, I want to be watered. I want you to give me hydration because I personally have a fear of being thirsty. And so mine's really specific. And it says, you don't have to do anything for me, but you got to treat me like a houseplant. Just water me. That's all I want. Because I have a personal fear. And so what that does is it tells your doctor directly. And the good thing about it is that doctors have an obligation to try to treat people forever and ever, right? This gives them permission to stop when it's time. One thing that you also check the box in this is, okay, what if I've said I don't want artificial feeding and I don't want artificial hydration, but my son over here who's got my healthcare power of attorney is saying, no, you need to give her artificial. Who wins? And there's a very specific part of this form that says, if your healthcare agent is saying X and your form says Y, which one should the doctors do? And you can do it either way. Some people would say, well, my son's got a better read on what the circumstances are. I'll trust him. And some of them are like, no, 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 no. My son's a tender-hearted guy. I know he's going to do this. I want this. And so you choose. And what that allows you to do is to decide now, while you're competent, what's going to happen when you can't speak for yourself. So those are sort of the big documents. You've got a will, you may have a trust. You're going to have a regular power of attorney, a healthcare power of attorney, and an advanced directive or a living will. Those are sort of the big documents people talk about when they talk about estate planning. And those are all things that people can help you with and have the right people there to witness them and notarize them so that you can do what you want to do. When I'm talking to groups about sort of end of life stuff, the other thing I just want to mention is that in addition to having sort of all these documents, there's also just things you can do to make life easier for the people who are left behind when you pass. One thing that's very helpful is that if you've named anybody in a will, make sure that the people who are left behind know how to get a hold of them. If you're leaving grandma's high school graduation ring to your cousin, Darlene, for goodness sakes, someplace on a piece of paper have Darlene's phone number so people know how to get a hold of her because your kids don't talk to Darlene. Have a list of the people that you want to be notified if you pass. Who are your friends that you do want somebody to make a call to that your kids might not think of? And how do you get a hold of them? If you have a pet and somebody's going to take care of the pet, who's the vet? Have the phone number for the vet. any kind of a helper like that. Also very helpful to have written down names and phone numbers and email addresses for the people who have your power of attorney and have all these things. So when somebody's going through your file and finds your power of attorney, they're like, okay, how do I get a hold of this person? Have all of that stuff written down for people. If you've got bills that you pay every month, have a list of those somewhere so your kids or whoever know what bills need to get paid or need to get canceled. You know, if you've got what is that thing in your car, Sirius? Well, let your kids know, I've got a Sirius account in my car. I'm not listening to the radio anymore. You want to go ahead and cancel that so it's not keep, charging up. If you've got things that are paid by auto debit out of your bank account, let your kids know that so they know that they should cancel those things, whatever those things are. If you've got life insurance policies, make sure your kids know where they are. If you've got passwords for things, and this is tricky, got a password for your bank account. Be great if if you trust your child or whoever knows where to find that password, but you got to balance that with also wanting to keep your stuff safe. So that's a trickier one than it used to be when I gave this talk 20 years ago, because everything's more scary now about passwords. But somebody ought to know how to log into the things you need to log into. If you've got a pension, somebody's going to have to tell the pension company, because either maybe you got a little benefit left over, somebody's going to get paid. Well, they need to know who to call. Make sure somebody knows where you keep your wills and your important papers and your keys and just anything like that. And finally, if there's anything that matters to you about your memorial service, make sure you've got that written down. If there's a Bible verse, means something to you and you want it read. If there's a hymn and it means something to you and you want it sung, write it down. My mom told all of us, my mom was from Holland. She told all of us, I want this one hymn sung at my funeral because it's a hymn that I grew up with singing in Holland. I had scrambled to find it, but at least I knew the name of it. And they played it at her service because it mattered to her. If there's somebody you want to speak, if there's somebody, any of that stuff, make sure that the people who are there, who are dealing with their grief and are scrambling around because we got relatives coming into town and how are we going to feed everybody, that they can go to one place and find all that stuff to make their time easier. I think that is everything I wanted to put out to y'all today. And I know that some people had questions, and I'm going to try and answer the questions that people had written in. And then if there's other questions, I can answer those. But I want to just sort of generally say, this is a menu, right? You don't have to do every document on this menu. There may be things you're not comfortable doing. Don't do them. There may be things that you're not sure what you want to do right now. You can wait up to a point. You can always change anything as long as you're competent, except for putting things into an irrevocable trust. It's called irrevocable for a reason, and it means that's it. You shut that door. But, if you say, I don't want to do a healthcare power of attorney, I don't like that idea, great. But then do a living will. If you say, I don't want to do a living will, then do a healthcare power of attorney. You should be putting some of these documents together for yourself, but you get to pick and choose. We're all different. We all got different situations. We've all got different needs. And so, take some time. I think you all have the handout. Think about what you want, make some notes to yourself, and then talk to somebody about what it is you want to do and how you can do that the way that it makes sense for you. So I think that covered everything. We've got time for questions. There were a couple of questions that came in when people logged in and signed in for things, and I've got some of those, so I'll just address some of those right now. Somebody had asked whether it was possible to have a will that had conditional terms. And I think what they mean by that is, can they say, I'm going to give my ruby earrings to so-and-so if X? Absolutely. I could say, I'm going to give my coin collection to my son-in-law, but only if he's married to my daughter at the time. If he's not, then that rat pink doesn't get anything. Or I'm going to leave, I don't know, whatever, my car to so-and-so, but only if she's living with me. I'm going to live my house. A lot of people live with a relative. I'm going to live my house to my sister, but only if she's living at the house at the time. Otherwise, I want that to go to my kids. They can sell the house and go to my kids, things like that. Somebody else had asked a question about how do I choose the right advisor? And that's a really good question. The best advice I can give you on that is don't pick an advisor who has something to sell. I would rather pay somebody for an hour of their honest time to give me their honest opinion than talk to somebody who says, I'm going to give you financial advice for free, other than like a Habitat or something that's a nonprofit. But, you know, somebody who has an advertisement that says, come on in and talk to me. First hour is free. They got something to sell. And they're going to want to sell you a life insurance policy. They're going to want to sell you an annuity. They're going to want to sell you something. And so the advice they give you is all going to point you right to that. So really the best advice I can give you is find somebody who sells their time. An attorney sells her time. A CPA or an accountant sells their time. That's fine. So I'll pay you $100 to tell me what I need to do. But somebody who's over there waving a big flag saying, I'm going to do it for free. They got something to gain unless it's a nonprofit like Habitat. In particular, one thing that people really like to talk to you about are annuities. And there's times when an annuity is a good thing. I am not an expert about annuities. There's times when an annuity is a good choice. An annuity says, I'm going to give you a bunch of money now, and in exchange, you're going to pay me X amount for the rest of my life. Sometimes that can be a good deal and sometimes not. But it's a gamble, right? I'm gambling that what I give you now, I'm going to live long enough that I'm going to get more than my value. But nobody sells anything if overall they're going to keep losing money. Casinos don't stay open and lose money. Insurance companies are like your house insurance or your car insurance. They have to make a living. They have to be profitable to open their doors next year. So they have to assume that overall what they're getting in premiums is going to be less than overall what they're going to have to pay out. So it can be a good thing. I mean, insurance is good, but understand nobody's doing this out of the kindness of their heart. So then another person had asked, once I create my estate plan, should I file it with the courts? No, nothing gets filed until you pass away. You just want to keep it in a safe place, hopefully a fireproof place, and hopefully a place you can lock up, or just in a desk drawer. I mean, you know, as long as it's a safe place that nobody can sort of get at it and get in it. But no, nothing gets filed until after you pass. So I think those were the main questions and then there are a couple of questions about how to protect my house. And we talked about some of that with a Medicaid trust. And that's really, I think, what most of those questions were kind of driving at. So I'm hoping I've kind of answered those in my discussion earlier. Is there anything else that people have asked in, or if anybody else here has questions?
We did have one question come in online. What are the fees for each of these documents? Will, power of attorney,
Sure.
trust?
There's not a fee for them per se. The healthcare power of attorney and the advanced directive are both forms that the state generates, and then you kind of check initial boxes and sign them. So those you can find them on the internet, the state forms. There's not a fee per se for a will or a trust or any of these documents, but if you're talking to an attorney who's not like at a will clinic, they're going to charge you whatever their hourly rate is, or maybe they have a little package rate. I'll do these documents for you for X amount of money. And that totally varies on the person and the attorney. There's probably attorneys in town who'll do it for $250 for everything. And there's attorneys in town who, will do it for thousands of dollars because they're going to do all sorts of other tax planning and other stuff with it. So there's not a set fee.
So you contact who about that?
So you can contact a couple of people. I know there's a will clinic coming up. When?
Yes, in just a few minutes, once we have gotten through questions, we will talk about a upcoming opportunity for a will clinic that we're putting on with different organizations in May. So that will just be for a will and power of attorney and things like that. As far as for a trust, if that is something that you were interested in, I can look at maybe sending out some other resources. But this will clinic will be for a basic will or power of attorney, something like that. That we'll go over in just a few minutes.
Yeah,
Question, when it comes to the trust, I noticed you mentioned that if you have a will, the pension, life
Uh-huh.
insurance, bank account, it's not a part specifically of the will. Can it be a part of the trust?
sure. That's a great question. So I don't know if everybody online could hear, but she asked what, I had said that some of these things pass around your will, like a pension and an insurance policy pass around your will. How can you make that work with the trust? You can, on your pension beneficiary form or on your life insurance policy, you can say pay to my estate. And if it does, it'll go through your will. Or you can say pay to my trust. And if that's the case, it will. So you can make it work with both of those, yes. Uh-huh.
You might have already answered this, but in 5 years, like you have to go into a nursing facility. So even if someone else is on your deed, you're still held accountable while you
Yeah, yes. So my understanding, and I am not an expert on Medicaid stuff, but I think the answer to that is if you and your spouse live in the house, they're not going to count it. But say you and your sister live in the house or whoever, and both your names are on the deed, they will still count that house as part of your asset. If you're living in the house, but you deeded it to your daughter 8 years ago, but you're still living in it, that 5 years has passed. You gave it to your daughter 8 years ago. Your name's not on it. It wouldn't be counted. So 5 years, if your name's on the deed, then it would be counted. Yeah.
We do have a couple of questions online that we can answer, and then we can do one more round in here, and then we'll talk about the upcoming Will Clinic opportunity. A question online was, will you have to pay Medicaid back if found over reserve / resource amount? What recourse does Medicaid have?
Okay, I am not a Medicaid attorney, but I believe I'm right when I say this, that if you went into a nursing home and that house was considered exempt because your spouse was living in it or whatever, or you went into a place and you thought you were going back home and they didn't count it and then you passed eventually, they can go back, and it's called they reclaim it. I'm not using the right word because it's not an area I'm super familiar with, but they can go back and get that asset. They have the power to do that. I just don't know the right terminology, and I'm not exactly sure how that works because it's not something that I am an expert in.
You need to pay for your services that you're getting. Okay.
Yeah, they'll go back and they will look and say, okay, she was in the hospital for X amount of time or in a nursing home for X amount of time, and then she passed. That her bill was X, and they can go back and take that much from the house. They can't take, if the house is worth $200,000 and it's a $20,000 bill, they can't say, well, we get the whole house. They can just sell the house and get that part of it out.
And that's with past debts due to
Healthcare, yeah.
well, I'm saying like past, let's say this person has all these credit cards or something.
Oh, right. So if you had credit card debt and that was your issue, let's put Medicaid out of it, say you're healthy, you got a bunch of credit card debt and you pass away, can they get your house? How it works, if somebody has a claim against you when you die, is that once you open up an estate, you've got a will or you don't have a will, and your child comes and says, I'm going to open up mom's estate. Then one of the steps in going through an estate is putting a notice that you've passed. And people usually do it not in the Charlotte Observer, but there's another paper that people put it in. In any case, your hospital or your credit card company or whoever will see that, and they can make a claim on the estate for the obligations that you owed. So, one of my daughter's best friends, her dad died. He drove a taxi and he died, and I'm helping her with his estate. And we ran the notice. Here comes the hospital. Here comes a credit card company going, he owes us money. Once they do that, the estate has to deal with them.
Mhm.
And so she went, my daughter's friend went, bless her little heart. I mean, her old 22-year-old self got on the phone and she negotiated like crazy with the hospital and with the credit card companies and said, I'm 22. I'm on my own. I need you to help me. I need you to come down on this. I need you to work with me. And they did. And they settled those for less. And she was able to, take care of them and still get a little bit of money to help her until, she kind of got on her feet more. But yeah. And if you say, well, then if that's the case, maybe I don't want to open an estate, then the credit card company can do it, step into your shoes and do it for you. If they think there's something there to get, they can make it.
What do you see?
Yes, go ahead. No, go ahead.
What do you suggest a good amount is for life insurance? Should it be
Sure.
10,000 for your burial? Or some people have 100,000?
Right.
What is the most affordable? I'm looking for the affordable one. In my world, I've always just seen the highest point being 10,000 for burial. That's what most people think.
Mm-hmm.
Should you go above that if you're trying to leave more money?
Sure, that's a good question. So if you've got kids or somebody else who maybe is counting on you to help support them, then you might want to go a little higher, right? Because you've got a job and you're taking care of your wife or your kid who isn't on their feet, or your wife has a condition, your wife's not working, your kid isn't grown yet, whatever it is, and they're counting on your support, then you might want to go higher. And if everybody in your life can kind of take care of themselves, then if you do a burial policy, that's probably sufficient. When my kids were little, my husband and I had more insurance because somehow those kids have got to get to the point that they're old enough to get a job, take care of themselves. And so we bought life insurance policies that ended when our kids were 22. Figured by 22, hopefully they're standing on their feet a little bit. And so, after that, we didn't, because that need wasn't there. I mean, a life insurance, if you just want to be nice and give people a present, I'm sure they'd appreciate it, obviously. But, the main purpose of life insurance is to take care of people that you're taking care of while you're alive.